Alright, so YNW Melly. That's a name that I haven't talked about on this channel in a while. If you've been with me for a minute, you know back almost 3 years ago, I covered the YNW Melly trial day by day, all the way up until it mistrialed. And I knew when it mistrialed that it would be a little while before we talked about Melly again. I didn't know it would be almost 3 years, right? But YNW Melly and his double murder case has been popping back up in the news here recently, mostly because his trial is set to begin in September of this year, and because Melly has been fighting for bond for over 6 years in this case. He hasn't been convicted of anything, but he has been sitting in jail for 6 years, and I think that's absolutely wild. Don't take that as me saying I think Melly is innocent, because that's not what I'm saying. But what I am saying is sitting for 6 years in jail unconvicted is crazy. Right? I do feel like sometimes people need to be detained to make sure that they don't flee before they go to trial. Like maybe a year or something at max, but 6 years is ridiculous. Either convict him or let him go is how I feel about it. But how I feel doesn't matter, because in December of 2023, Melly's defense team actually filed a motion for continuance. In that motion, Melly waived his constitutional right to a speedy trial. That decision allowed both his defense team and the prosecution team additional time to prepare for the retrial without being constrained by the typical 180-day time frame that's mandated by Florida's speedy trial rule. That waiver has contributed to significant delays in the retrial proceedings. It was initially rescheduled for October of 2023, but again, it's been postponed multiple times. Now it's set to start in September. And Melly's story is something that you really can learn from, because while waiving your right to a speedy trial can be a strategic move sometimes, in Melly's case, it's led to him remaining in custody for 2,276 days as of today, with pretty much nothing he can do about it except wait on trial and plead for bond, which is something that he has been doing. Now, Melly is on trial for the 2018 murder of his two close friends, YNW Juvie, also known as Christopher Thomas, and YNW Sack Chaser, also known as Anthony Williams. The government alleges that Melly, along with another co-defendant, YNW Bortland or Cortland Henry, staged a crime scene to appear like a drive-by shooting had happened, and so that's why he is in custody. He's facing 2 counts of first-degree murder, which are charges that have the potential to result in a death sentence if YNW Melly is convicted, and because of that and several other reasons, prosecutors have argued that he poses a significant risk if he's released. Right, while he's been in custody, he's been accused of witness tampering. Those allegations come basically from Mariah Hamilton, which is Melly's ex-girlfriend, and Felicia Holmes, which is his ex-girlfriend's mother. Prosecutors claim that Melly used intermediaries to communicate with gang members and tried to dissuade his ex-girlfriend from testifying, and then pretty much they did the same with her mom, trying to prevent her from testifying. The prosecutor argues that those actions demonstrate a concerted effort to obstruct justice in his ongoing legal proceedings, meaning that if he's let out, he could continue to try to obstruct them. They're using that to try to keep him detained. They're saying that he's dangerous because of what he is charged with and the fact that they claim that they have evidence that links him to the scene of the crime. So they're arguing that there's a dangerousness perspective to it if he's let out, and then also they're saying that there's a risk to public safety and that Melly is a flight risk because Melly has money. They're saying he basically can disappear and leave the country if he wanted to. Despite that, Melly's defense team has proposed strict conditions to the court that he would follow if he was allowed to be released on bond. Those conditions include house arrest, 24-hour private security, GPS monitoring, and they even have his record label prepared to post bond for him. However, the judge has previously denied bond, and a decision on his latest request is still pending, and that brings us into some footage that we got today from the courtroom where we get to see YNW Melly's defense team and the prosecution go back and forth about if Melly deserves to have bond or not. All right, let's take a look.
There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight. Is he a risk of flight? So going through that, what we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to. One, it was twofold what I had asked for. Mr. Demons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. So you basically have your own deputy, paid deputy, with him. Mr. Demons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm.
So basically what they're offering is what at this point I would consider like the standard rapper bail package, right? He's saying that he would do GPS monitoring, house arrest. He would hire a security company to keep watching him 24/7. This is something that we seen NBA YoungBoy do and get away with. This is something that we have seen Lil Durk attempt to do, but his judge hasn't approved anything like that. Yet. And this is pretty much the same bail package that YNW Melly is offering, except for he asked for a minimum cash bond, which means he don't want to be putting up $1 million in a bunch of real estate and all of that to secure his bond, probably because he probably just don't have it. He's been locked up for so long at this point. Like, I don't know what his money situation looks like, but I'm sure his legal defense is costing a ton of money, right? So he asked for the minimum bond and then all of the regular stuff that we're becoming familiar with rappers asking for. His defense also argued for him to get bond based on the fact that he has been incarcerated for such a long period of time, 6 years. They try to mitigate the worry about him being a flight risk by saying, hey, look, when he had the opportunity to run back in 2019 when he was arrested, he didn't. He turned himself in. They try to use that to get around the flight risk. They try to say, hey, look, Melly didn't know anything about Mariah Hamilton coming to testify. He didn't tamper with her. They try to get around that. All right, pretty much they give the best argument that they could give given the circumstances to try to get Melly bail.
that case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demons' trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that. And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not, did anything. He did the right thing, Judge, and he turned himself in. I believe February 13, 2019. 6 years ago. Spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence of that.
Okay.
The lawyers don't give evidence. So if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't consider it.
Okay, good.
You're just saying it, so go ahead.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community. See his mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That proof of great, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those 3 things? To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demmons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we have met it. The state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant, it's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected.
Yeah, so that was pretty much their whole argument for why Melly should be released on bail. Of course, when the prosecution got their chance, their best argument for why he shouldn't be was that Melly killed 2 people. He has committed murder that could result in the death penalty. And because of that, he shouldn't be released.
The defendant's charged with homicide. He's killed 2 people, so he's clearly proven himself.
Allegedly.
He is.
Please, one at a time. Go ahead, sir.
He has already established that he presents a danger to the community, but not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody, because he did have a bond and that bond was revoked. Had Mr. Demmons been on bond, his bonds obviously would have been revoked and he'd be back in custody as well, because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Demmons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater, because it is going to be much more difficult to recover him should he leave the jurisdiction.
Okay.
May I respond, Judge?
Okay, last word. Go ahead.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. I can give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be, if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we'd have conditions in place to ensure. As far as what the state's arguing that they're afraid he would leave, I again think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day and another individual monitoring the property. They would be reporting back to not only the defense team, but the state attorney and to the court if there is any issue. Again, the ankle monitor is being monitored. I've had other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Demmons, while being on house arrest and a GPS tracking monitor, had absconded to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those three different combined statutes. It's protecting the community, protecting the integrity of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
And with that, YNW Melly is hoping that he will get bond granted. I'm not gonna lie, the judge was shaking his head at one portion in that when she was talking about the record label putting up the money for him to get bond. The judge was pretty much shaking his head no. You could tell he didn't like that idea. It then zoomed over to Melly. It kind of looks like it might have hit Melly that the judge wasn't feeling this and that he's probably not going to be granted bond. I mean, at this point, they haven't given it to him in 6 years. Why the hell would they do it now? He gave up his right to a speedy trial, so that's kind of his fault, or at least that's how the court sees it. Now, everybody was hoping that the judge would make a decision, but he told everybody that he needed a couple days to think it over and that he would be filing his response, his answer to this request in the next couple of days. I'm gonna be keeping my eye out for it. Y'all know if it pops up, I'll bring it to y'all so y'all know exactly what the judge says. But for now, man, that's what we got. That's the video. Y'all gotta let me know what y'all think about it in the comments down below, because that is basically it for the video, guys. If you enjoyed the content, be sure to hit the like button, subscribe, tap the notification bell so you get notified every time I upload a video. As always, it's been fun rocking with y'all, man. I kind of enjoyed this right here. Reminding me of the old style when I covered the Melly trial the first time. But anyways, I'm out.